Hello and welcome to The Docket, presented by Defense Stars. I'm your host, Bob Mata, and I am joined by my beautiful, brilliant co-host, Allie. What's up, girl?
Hey, babe. Hi, all.
Hey, all. Thanks for coming back. We definitely had a long day on Karen Reed. Come to find out, there was a little order by Judge Gull. Thought we'd check that out. For those of you that are not aware of what this case is about, it's a case of Richard Allen. And the people of the state of Indiana are seeking to convict him of the murder of both Abby Williams and Liberty German back in 2017. Case went cold for 5 years. They finally made an arrest. Richard Allen was the guy. And we have been plowing through the procedural history of this case for the last, year and a half?
Something like that.
Something like that. So basically where we're at today, Judge Gull has ruled on the defense's motion for recusal. Actually, their second motion for recusal. It came as no surprise to me, obviously, that she denied it. But I thought it would be cool if we check out the order. It's lengthy. It's got a little girth, this order. Yeah?
Yeah, I mean, she provided some findings of fact.
All right, so this strange-looking little circle is our esteemed colleague and friend, Michael Ausbrook. Can you hear us, Michael? Can you hear us?
I can absolutely hear you. Nice to
Good
meet you.
man. Welcome, my friend. How are you?
Thank you. Doing okay.
I know you've had better days. Michael sadly had a beloved family pet that they had to put down today, so everybody be kind. Tough day for my friend. I'm glad that he was able to join us for a bit. So we won't keep you long. We have a couple of orders we're going to go through. They're relatively quick. We'll have some nice discussion about what we think it means moving forward in the case, and we'll go from there. All right, so first thing we're going to go over, so she issued a couple of orders. Both came down today. Well, actually, this one looks like it came out on May 31st, 2024. So a few days ago. The court has reviewed defense counsel's petition to strike gratuitous and demeaning commentary and or findings from contempt order filed May 8th, 2024. As the court granted counsel Hennessy's motion for specific findings of fact and conclusions thereon, filed on March 12th, 2024, this motion is denied. Which
So
this order is hilarious.
Right, and that's what I was going to say, and I wanted to ask Michael, like, isn't it odd that, she grants the motion for specific findings of facts and conclusions of law when she wants to, extrapolate about how bad the defense counsel is doing, but then denies it, even though she did proceed to then make findings of fact in the motion to disqualify.
I don't know. There are cases that say contempt is its own thing. It's not a criminal case. It's not a civil case. I think
So this. Got it.
So she could have done that to cover her. I mean, the trial rules do not apply. The Indiana trial rules do not apply to the criminal rules, to criminal cases. So I can see sort of why she provided findings of fact in the contempt order and not here.
So what Michael's saying, and I contemplated that as a possibility, but still found it convenient for her. But I see what you're saying is that the contempt order sort of is the final order that resolves the entire contempt thing. So it is more like a judgment and like a final order, and that there's some procedures in the rules that would require findings of facts with contempt. Are you saying that as well, Michael, or is it more the finality of that one issue has come and gone with that order?
I'm saying it's completely unclear whether the trial rules apply. So if criminal contempt, so what I was saying was a number of cases say that contempt, criminal contempt, is not a criminal case. It's not a civil case. It's its own thing. That means it's not clear whether the criminal rules apply or the trial rules apply or neither. So Judge Gull, by including the findings of fact and conclusions of law, covers that base in case some higher court were to treat it as
being covered by the trial rule.
Right.
Got it. Okay. Makes sense.
Okay, so my take on this particular very brief order is that
you got what you asked for.
Well, no, her stating, as the court granted counsel Hennessy's motion for specific findings of fact and conclusions thereon, that she's saying that she finds it to be a fact that both Baldwin and Rosie are sloppy, grossly negligent.
For sure.
I think it's an absolute slap in the face. She's saying, I gave you wanted conclusions of fact. I gave you conclusions of fact. You may not want to hear them, but I think that Baldwin and Rosie are sloppy, negligent, all the things that she said. So
right.
I thought it was, that's how I read it. All right. So that one was short and sweet. This next one's a little lengthier. And this next one will spur on some pretty interesting conversation as to where this case goes from here. So order of the judgment of the court. Now, this did come down today, correct, babe?
We received it today. I don't know what date the judge, I can look on my side. You don't have to scroll all the way down. It shows May 31st was the date that it was executed, but we received it today.
Okay. Let me see. I don't want to edit on. Okay. All right. So the court has reviewed the defense second verified motion to DQ judge and request for findings of fact and conclusions of law. Upon denial of this request, if the court denies this request filed May 17th of 2024, as trial rule 52 is not applicable in criminal cases, the defendant's request for findings of facts and conclusions of law is denied, citing Neely and Davis v. State.
And that's what Michael was just speaking to. So
Correct.
That rule does not apply to the motion that she is writing this order on or any of the other criminal cases. Hey, Michael, are there any criminal issues that come up in criminal cases that do require the court to make findings of facts and conclusions of law, separate from Rule 52?
Only in post-conviction cases.
Gotcha. All right.
And you all know as well, or maybe even better than I, since you all are the trial lawyers, judges are better off when they say the least.
Right.
For sure. Less is more. The court will address each of the defendant's allegations in this order. Defendant claims that the court directed the Carroll County Sheriff to ignore a subpoena. The court directed an email to counsel on June 14th of 2023 regarding the witness refusing to cooperate with the service of the subpoena and demonstrating a willingness to fight the deputy attempting service. The court requested a report of the witness's refusal to cooperate and be transported for the scheduled hearing and forwarded that report to counsel when it was received. The decision by the deputy to leave without the witness was his and was not directed by the court.
So on that issue right there, and Michael, correct me if I'm wrong, that's basically if they appeal, that's a fact that now the courts have to accept that this deputy made this decision on his own without any influence from the judge.
I don't think so. That absolutely contradicts Lesenby's testimony, I believe, that he was directed by the court. So I don't think that has to be accepted.
So when the court's confronted with conflicting, when an appellate court, a higher court's confronted with conflicting evidence of the record, including the judge's own, the judge's take on that, you're saying that they don't have to default to accepting the judge's take when they see contradictory evidence in the record.
Well, it's not going to happen. But the beautiful thing about an original action in the Indiana Supreme Court is it's an actual trial. They could actually get Lesenby and Judge Gull in there to testify and judge their relative credibility. They're not going to do that, but between Lesenby and Judge Gull, appellate court's probably going to accept Judge Gull. Who knows?
All right, let's keep plowing through. So defendant claims that the court engaged. So this is the next. She's now addressing the next thing. Defendant claims that the court engaged in ex parte communication with the Carroll County Sheriff regarding defendant's housing, transportation, and safety during the jury selection in May 13th through 31st, 2024. These communications were administrative in nature and did not address any substantive, please hold, issues. The communications were directed toward the defendant would be housed during the trial and who would be conducting transportation. The court did notify counsel where defendant would be housed during the trial. Parenthetical is he is still under the safekeeping order in an email, but did not inform counsel of the communication. Nothing substantively was discussed. The court has set the defendant's motion to vacate safekeeping order for hearing, but was required to cancel the hearing upon the filing of this pending second verified motion to DQ.
Now, Bob, I want to refer back to what was said, speaking of contradicting information, what was said in the motion. And I'm going to assume either an email exists or it doesn't. So I'd love Michael's take after I read this. So coming from the motion that was filed by the defense, they said that during the May 3rd deposition, and let me just double check if that's of Liggett. Yes, of Liggett. Oh, right. Sheriff Liggett acknowledged that Richard Allen was set to be housed at is it Tippecanoe?
Correct. Yeah. I mean, in the original hearing, they had it set up for Cass County.
No, I just wanted to make sure I was pronouncing it correctly.
Oh, Tippecanoe is correct. Yes.
At the Tippecanoe County Jail during the scheduled jury trial, and that transportation of Richard Allen to and from the courthouse was arranged. Therefore, there is no reason to continue to house Richard Allen at the prison some 2.5 hours from Carroll County during the pendency of this case. Then it goes on to say, next paragraph, according to Sheriff Liggett, Judge Gull is aware of these circumstances. Next paragraph, despite this, Judge Gull failed to communicate or even inquire with the defense about Richard Allen's housing circumstances. So do you see some way to reconcile those two statements, Michael?
No.
They're irreconcilable.
Well, I mean, I think Judge Gull is taking it as, I get to say where Rick Allen is going to be housed during the trial. It's really none of your business. I'll let you know after it's been done.
But she's saying in here, she sent an email to them letting them know, right? Isn't that what it says in the order, Bob, that the judge says, the court did notify counsel where defendant would be housed during the trial in an email. So correct. I don't know if the defense is being disingenuous in the way they're writing this, if they're writing in a way that's I don't know.
So I forget already, but how it was stated in the motion, but I think they're objecting to having simply been told after the fact without being consulted.
Well, they said, despite this, Judge Gull failed to communicate about Richard Allen's housing circumstances. But I hear what you're saying. Is maybe they're saying, like, failed to communicate about it during the discussion and only told us afterwards. But the way the motion is written, it makes it seem as though they were never told that this decision was made to house him there and that was an available option. So that's where I'm just a little bit like, it's an odd discrepancy between the two.
Yeah, I don't disagree, and Brad and Andy are trial lawyers, and they're you all are trial lawyers. Trial lawyers are in a hurry, and they may not have put it exactly the way they meant to put it. I mean, it's an interesting question to me why Judge Gull has anything to say about where Rick Allen is housed during the trial. Under the safekeeping order, he's in the custody of the DOC. she can order him to be produced at trial, but as long as he's in the custody of the DOC gets to say where he is. At least that's how I read the rule or the
Right.
statute. And basically, she can tell the issue a transport order, but I don't think she can order that he be housed someplace else unless she's undoing the safekeeping order.
Right. And that's kind of the conundrum with this. You know, I mean, when we were trying to get Garcia moved for pretty similar type circumstances, frankly, I mean, we had to go in front of the judge in order to try to get them to write an order moving him. And that went, you know, to no avail with that. And ultimately, it got to the point where his mental health deteriorated to where we were challenging his competency, which frankly, to be honest with you, I'm still a bit surprised that hasn't happened here. I don't know what the law is, Michael. Maybe you can enlighten me. And just so you guys know, Michael Ausbrook is a brilliant attorney, habeas guy, had a program at Indiana University, which for some godforsaken reason has shut down that habeas program. And Michael has done work with the defense team, not on the underlying case, but with regard to the case against Andy and Brad with respect to their removal. Just for a little background, I saw somebody ask in the chat. But what is the, do you have any idea what the process is in Indiana with respect to challenging a defendant's competency to stand trial?
Yeah, you ask for a hearing, and you know, you put on the experts, and and basically, if there's any reason to think that a defendant is not competent to stand trial, the hearing has to happen.
In Illinois, you have a right to a jury trial, like on the final decision of that. Do you have that right in Indiana?
I've never seen a jury trial on competency. You can get an instruction in Indiana on the voluntary, so the jury does get to rule on the voluntariness of a confession.
Right. In that sense, though, they've got an opinion. Yeah, I think it's something unusual to Illinois that you can demand a jury on your competency determination. But one thing I thought from this, in the way that she has worded it, she turning back to Judge Gull, is like, all right, yeah, we do have alternate arrangements available, and if you wouldn't have filed this damn motion, then I might have moved him. You know, now it's going to take. So I'm just reading tea leaves. Like maybe by the time she ultimately sets this, maybe she will grant it, and then be like, see, the defense delayed this with their motion to disqualify. But
Absolutely possible.
All right, let's keep plowing through. Counsel claimed that the court invited the state to limit the defendant's Sixth Amendment right to present a defense. The court has always required counsel in all criminal cases to follow the law relating to third-party perpetrators. The court reminded counsel of their obligation to follow the law in the court's email of April 28th, 2024. I didn't quite read that as a reminder, but maybe that's just me from that particular email.
But so her answer there, at least as I read it, is a total non sequitur to what Brad and Andy were saying. I mean, third party, whatever it, I mean, they said they were limiting their ability, state was limiting their ability to put on a defense. I read that as like limiting in the sense of, we may not have, the state's going to get as many days as it wants. You've scheduled this for X number of days, and you're not giving us, you know, enough time, or guaranteeing us enough time to put on a defense, whatever that defense is. I don't see that. I don't see what they filed as being necessarily saying, you're not letting us put on our third party defense. It's, you're not giving us the sufficient time to put on any defense.
well, they raised two issues, Michael. First, they said, so the judge sent an email that email out that was like talked about the length of trial, and also mentioned like, hey, I'm fully aware that, you know, you've got to establish certain things before you get in your third party evidence, and, you know, I'll rule on that accordingly, as a like, hey, state, why haven't you filed anything saying that they shouldn't be allowed to put on a third party defense, that they haven't reached their burden, you know, to allow it. And then the state immediately after that filed the motion. Now, you know, like, I know when I read it, I was like, "Oh, hey, thanks, Judge, for reminding the state to do that." But I do also see it as like it's her docket, and it is something that's really is supposed to get done beforehand, I think. But love to hear your thoughts on either the defense bringing it up and seeking ruling in limine that it's going to be allowed, or the state trying to challenge it once it's been raised by the defense.
I guess what I was trying to point out is I think there are two different issues, and I think she only addresses one of them. There is the time issue and there's the third party defense issue. And I think they were complaining about the time issue. In other words, the part of her favoring the state, part of the evidence of her bias is she wasn't willing to guarantee them time to put on their defense. Whatever the third party defense result is, they weren't being given time. Basically, the way it went down, as I understand it from the transcript, was, hey, we got this number of days, and if Nick McClelland takes them all up, I'm sorry, you're out of luck.
Right. And they do bring that up. I think she does address that time in a later part, and just blames the defense.
Well, I didn't put a tweet up today about it, but what, you all are into day 19 of the Karen Reed trial?
Indeed.
And that's a single murder that at least wasn't the murder they say it was. and it's 19 trial days
right
already. And it's also not 7 years after the case was dead for 7 years. It isn't after the destruction of all kinds of evidence, intentional or not. And the idea that, I've seen some lawyers on Twitter and elsewhere say, I could do this in 3 days. Maybe Libreto said he might take 3 to 5 days. I don't know. In that interview he did.
That's impressive. That's very impressive.
Well, it's
I'm being sarcastic.
Yeah.
I tend to think that they were addressing both issues. I think that they were absolutely addressing Michael's point, which was that she was cutting him off at the legs. She set a hearing date and said that this isn't a more or less proposition, that it's set for exactly the amount of days that I said it was, and not a day more, and act accordingly. And they were saying, okay, well, McClelland could take up the entire time that you've set it for, leaving us the ability to put forth no defense, let alone a third party culprit defense. But I also think that they were coming at her, stating, look, you're putting in an email that you're essentially shutting down our theory of defense without the benefit of a hearing, even, which obviously she remedied, which she likes to continually point out that all of those have now been continued as a result of them filing the second motion to DQ. It's your fault, guys. I was going to hear that, but now it's your fault. This delay is your fault.
But I was only going to hear it once you asked for a continuance.
Right.
It wasn't set before that.
Right. It's funny how that works.
Right.
Which, I've made my theory on, this was orchestrated by her. She knew that they were going to have to ask for a continuance, just how she was operating.
Well, I think her limitation to the number of days was also, I think, and I could be wrong, but I think it was based on a misreading of the jury rules. I think she was sort of thinking the jury, well, it's a May jury, so they have to be finished in May, and that's just not true.
Yeah, I agree. I don't know if it was a misreading or it was just her deciding to try to cram a round peg in a square hole and make it seem like that was a reasonable explanation for it. So I don't know. I mean, who knows with her. Moving on, counsel claimed the court has disparaged them and ruled on defense pleadings without hearings. Well, I mean, she has. The court's comments about counsel's performance were documented in the court's order of April 30th, 2024, regarding their handling of discovery materials. If pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. What say you two, to this fine paragraph?
I absolutely agree that there's a lot of stuff that doesn't require a hearing, and people have been complaining that she hasn't held enough hearings. I don't think in their recusal motion they bothered to mention that she offered Libreto and Scremin a hearing on the Franks motion and then immediately denied their Franks motion after they were back. At least I think that's what I recall the timing of it was.
That would have been an interesting fact to include in their allegations of treating people differently.
Among other things. As far as her taking a swipe at Brad and Andy in the April 30th order, it was completely gratuitous. It was absolutely unnecessary to the contempt.
Yeah, and I don't think she limited it to the discovery issue. To me, it read as a general proclamation as to their overall performance on the case. That's how I read it. I'm sure that's how Andy and Brad read it as well.
Yeah, and 2 weeks before a trial was supposed to start and a jury was supposed to be selected. And I mean, there's really no excuse for it. I mean, none.
I agree, and I think Michael and I sort of ranted about this back when they filed this motion, and that we had thought that they should have also focused. I know Michael had a ton of things in his mind that he didn't go through all of them that he thought should have been included that weren't, and we just heard one pearl just there. But that Mike and I were both like, what about the impact this has on the potential jury pool when the judge puts something like that out 2 weeks beforehand? That could have been something that was highlighted more in the motion.
When the jury is coming from her county.
Exactly. Her county, which is significant because, I mean, if you're bringing a judge in from another county, that's one thing. But when you're bringing the judge in and then it so happens that the jury, the veneer is going to be transported from that very county where that judge sits, it then becomes a news item in that county. Whereas like the typical move is that you're trying to import a jury from a county that's not familiar with the case. So that was absolutely destroyed when they decided to have the jury come from the judge's very county, and she made it so. And I guess that could be argued many, many different ways, but that she became a major part of this story. A lot of times you won't hear about a judge until trial. She has become a major, major player and character in this story leading up to trial in a way that I frankly can't remember ever hearing about this much about a judge leading up to trial. I mean, Cannoni and Reed, I mean, I heard a lot about her, but not to this extent. I mean, they tried to get her bounced for bias in that case as well. She too denied it. But with respect to Gull here, I mean, think about it. Like, can you think of any case in recent memory, aside from Reed, wherein you've heard this much about a judge leading up to trial?
Not leading up to trial. I mean, obviously Ito and the OJ trial during trial.
Right.
But pre-trial, no,
No.
I don't think so. And it all started with, boy, I'm the judge, and there's that discovery leak. I'm handling that. I'm letting law enforcement handle that, and whatever I say to the lawyers is behind the scenes.
Right. Absolutely. All right. So allegations the court has treated the prosecution more favorably than the defense are unsupported by any admissible evidence provided by the defense at the March 18th, 2024 hearing. The court was notified on May 20th, 2024 of an inquiry by the Indiana State Police to the court reporter via email on May 9th of 2024 regarding ex parte communication received by the court from Gary Baudet, which was previously provided to all counsel. The court is unaware of the extent of any Indiana State Police investigation.
So I just want to start by asking, to me, what I found most odd is that the court is relying, she says that these allegations that she treated the prosecution more favorably than the defense are, quote, unsupported by any admissible evidence. Now, this is the highlighting part to me, provided by the defense at the March 18th, 2024 hearing. Now, as far as I'm concerned, first of all, they were very limited. She would not allow them to put everything that they wanted to put in their March 18th, 2024 hearing. She claimed that the four corners of the motion didn't cover everything they wanted to put in. And this encompasses way more than what was on the table for that March 18th hearing. So why is she relying on that if she thought that there might be, that it was unsupported by any admissible evidence, give them the opportunity to have a hearing and put forward admissible evidence? What do you think about that, Michael?
Yeah, but admissible evidence, I mean, that's also kind of nuts because she can take judicial notice of the entire record in this case.
Right.
I mean, the entire record's in here, and I guarantee you, if this ends up in an original action or an interlocutory appeal, that they're not going to need admissible evidence because there's the record.
Right. But the fact that she's relying on what was put forth at the hearing as opposed to the additional information, like you said, that she can take judicial notice of in the motion itself, do you find it at all strange that she's referring back to the March 18th hearing when the new motion encompasses more information?
The new motion, so the recusal motion wasn't heard on the 18th. They started to hand it in. She wouldn't let them, and then they never filed that motion. So the hearing then there were two. There was the criminal trial on contempt, and then there was the motion to dismiss.
Right. So yeah, why does she keep referring to this May 18th, the evidence that was put forth at the May 18th hearing?
Why people in this case do what they do not ask me.
You're
'Cause I
talking
think
about
she does
talking about the March 18th hearing.
March 18th, sorry, yeah. Because I thought she did that in one of it's like, I don't know why now that Michael's saying, because in my mind, I just started to think, well, there must have been a hearing on this. But right, there was never a hearing on this. So that makes it even more bizarre to me that she's talking about evidence that was admitted at a March 18th hearing that didn't have to do with this.
Well, I mean, I was there, and I could tell you that in her mind, Baldwin was, in his motion to dismiss, was intimating a couple things, and as was Hennessy in the contempt motion portion of it. He was intimating that they were getting favorable treatment because of the things that you've said, Allison, like when we're off air, like, oh, McClelland's reading ex parte shit. I fully expect to have Gull undress him publicly the same way that, that she undresses the defense team, the things that you would expect. So those kind of things were argued. Beyond that, they argued and they felt that it was powerful argument that there's been either intentional or accidental destruction of evidence. And yet again, she does nothing. You know, there's this leak that happens, you know, allegedly out of the defense's office. And, you know, she flamethrows them. She uses a camera for the only time ever in the entire history of the case, and then has these guys, you know, gives them a Hobson's choice to either withdraw or she's gonna boot them either way. So, you know, and then again, she does nothing, doesn't even mention it at all in any capacity with respect to what McClelland and or law enforcement may be doing on their end of it. So I think it's tied into that. I think that's what it's aimed towards.
Well, and then, and the, you know, one of the things they left out of their recusal motion was that, she held a criminal trial of Brad and Andy that was completely unauthorized by law inside Richard Allen's criminal case. And then even if you thought she could do that with so she set a speedy trial date. So she took up when it was quite reasonably suggested, let's handle this later. She decided to take up everybody's time in March with the contempt hearing when there was a, you know, really big trial coming in May. And as you've been saying, 60 days ain't nothing if you're going to trial. You know, not even asking for a response from McClelland, you know,
speaks volumes. It speaks volumes. I mean, at least in my world, it does. It speaks volumes as to her treating the prosecution more favorably.
Yeah, the motion
like, I mean, typically a judge will say, okay, well, you know, Mr. McClelland, I want you to answer that. I want you to answer their accusations because they're powerful. You know, they have weight. But when she doesn't require that, I think it does show bias. But what do I know?
Well, I mean, I look, I mean, obviously everybody's different sort of judge, but man, if I were the judge and I got what I filed February 8th,
that's what I was going to say. You gave them a lot to work with in that motion, and that they could have incorporated into this motion to disqualify. You gave them a lot to work with.
Well, but I'm also saying that, you know, I'm happy to be wrong. I mean, that's what the cases seem to me to say. And if I'm a judge and that comes into me, I'm going to look at that and say, you got any answer to this prosecution? And I'm not going to summarily deny it, because I certainly don't want to do something I can't do. And you know, having this trial inside Richard Allen's criminal trial was about the fourth or fifth thing that she did that she just can't do.
Right.
Well, I mean, you're a reasonable guy, though.
And so for anyone who doesn't know, Michael had filed a motion challenging, and maybe you can quickly explain it instead of me trying, Michael.
Okay, well, I filed a motion for summary denial of the contempt information that McClelland filed, because it couldn't be civil contempt, because there's no remedial. There was nothing the court could order to fix the situation. And so it had to be criminal, and it had to be indirect criminal contempt, because whatever happened didn't happen in the presence of the judge. And that has to be filed as a separate case, probably in this case with a separate prosecutor, because what? You can't have prosecutors using their contempt powers to go after the other side.
Right. I want you to boot them off.
Yeah, right. And again, you know, I put the law in there as I found it. If you know, there are cases saying I'm wrong, I'm happy to be wrong. I mean,
but she didn't even make them respond to it, which is an issue that they could have raised. That you raised a very, you know, an issue that she should have seen had merit on the face of everything, and just disregarded and didn't even require the parties to respond to something that she's confronted with that presented issue. Just went about to do what she wanted to do anyway.
Yeah, and for the record, I love that motion. I just want to put that out there.
I know.
I loved your motion. So, and I thought it was well pled. So, but.
And then I want to ask what about speaking to like the way she treated people differently? And I don't know if I've asked you this already before. So if I did, hopefully we've got some new people here that haven't heard it. But I found it to be an issue that he, being McClelland, read the text messages that involved attorney-client privilege. Like, why was he touching that? And that was one of the things, like Bob's talking about, where I'm thinking, all right, now she's going to have to slam the state for doing this. Like, they know better. If it comes across your desk and it's got some attorney-client communications in it, shut it down, tear it up, don't read it.
Are you talking about some of the Westerman emails?
I think so, or it was like a cell phone extraction that they had that included,
Yeah,
oh, it
his
wasn't
iCloud.
attorney-client privilege, but it was attorney, work product or thought process or something.
Well, Dave Hennessy made that argument. I don't think it was work product. I mean, Westerman
Because
wasn't. I mean, they said Westerman wasn't on the team. It wasn't, and yes, we all, as all the lawyers testified, we all consult with various people out there and talk to them about some stuff that's privileged. But when you do that, you take the risk that it gets into the wild. But I don't think the Westerman iCloud stuff, maybe when he was, so I don't know what the dates on all that stuff was. There was some allegation that Mitch Westerman had been working as a consultant with Brad and Andy up to a certain point, and I would say up to that point, those communications might have been privileged, but after that, I don't think so.
and maybe that is the only thing that I'm thinking about. Was that what that was all about, babe?
Pretty much. I mean, it was, and Michael was mortified when I told him that Hennessy had said in open court a couple of things. Number one, that it was work product, and that he made some kind of comment that could have been construed that Westerman was like a consultant of the firm, making it sound like he was an employee of it. I don't know. Yeah, that whole part of it was a mess. So yeah, I think so. I kind of took it as that way. All right, let's keep plowing
Let's
through.
go to the next one.
Defendant blames the court for ex parte pleadings. Wait, did I already read that one? No.
No.
Defendant blames the court for ex parte pleadings, which were inadvertently directed to the prosecutor. The defense staff filed pleadings and marked them as, quote, confidential, apparently unaware that the word confidential marking makes them available to the state, but not to the public. Counsel's staff contacted this court staff and were advised that the statewide Odyssey case management system, not DocsPop, as alleged in the pleading, has a distinct process for filing pleadings ex parte as opposed to confidential. The court did email defense counsel a tutorial paper authored by JTAC explaining the process. Since that communication, defense counsel have had no issues with their staff properly filing ex parte pleadings.
So, Michael, let me ask you. So, is there, so first of all, I was saying to Bob while we were off air, I'm like, if that's true, if the defense had to get this tutorial information and their staff is now filing it differently, why the hell even include this? Like, why say that it wasn't their fault? Is DocsPop another way? Because we can use Odyssey, which is the one I often use, but there's also other filing systems that you can use that's not Odyssey. Is this the difference between two e-filing sites or platforms? How do you read this?
Well, DocsPop is a place where you can get information. It's not a place where you can actually file something, I don't believe.
So is that like a typo, you think, that if they included it as DocsPop? I don't remember if they did or not, actually, but
I'm not sure. But my problem with this, and it's a factual dispute, and I don't have the answer, but my understanding is that there is an affidavit out there somewhere by the clerk of the Carroll Circuit Court saying that Brad and Andy properly locked those things down.
And that's what I thought. I was like, this is so bizarre because the defense is saying in their motion anyway, like that it was definitely not their issue. And now the judge is saying it was. And I mean, there is a difference, right, between marking it as, when we file, it says, non-confidential or confidential. Those are the two things you have to pick from. I am fully aware that if I am choosing confidential, it's just that the rest of the public doesn't get it. When we file ex parte here, we literally don't file it. We just deliver it to the judge. But is so your understanding of like the facts that have been out there are that the court staff has said the defense did it right, and now the judge is saying the defense did it wrong.
The Carroll Circuit Court staff says, and so one of two things is going on here, I think, and there may be other inferences, but the two are: one, Judge Gull is, well, three. One, Andy and the Carroll Circuit Court clerk's mistaken. Two, Judge Gull is mistaken. Or three, the leak's coming from inside the court and Judge Gull's covering. And I'm not saying she is. I mean, I'm just saying that's one way it's one way it gets out. I mean, I suppose, the Carroll County clerk could be feeding stuff to McClellan too. I mean, I don't know. I don't know what happened. McClellan said in his pleading, he just clicked on it, and that was open sesame, and there it was.
All right, so let's talk about that one then. So he does click on it. It says ex parte. He should shut it down right there.
He should. He absolutely should. And not only should he shut it down. I mean, if I'd be sending an email to Brad and Andy saying, by the way, I clicked on this, opened it. I didn't read it. The minute I saw it was ex parte, you might want to refile it.
Right.
Sinbad Sailor says if McClellan could read them, then they weren't filed as ex parte. What do you guys have to say to Sinbad Sailor?
Well, that's what we're saying the dispute is that to Michael's understanding, there's something out there where the Carroll County clerk says that the defense did file it right. They did lock it down. It should have been ex parte, but the judge is saying that they didn't do it correctly and it was their fault and she had to send them tutorial. But if whatever happens and by some accident or inadvertence or whatever, an ex parte document comes across the desk of another lawyer, the opposing counsel, they are supposed to not read it. They can see the words ex parte right there. Just because you get something accidentally, you're ethically bound. You know what it is. Shut it down. And just like Michael said, let somebody know that something that is supposed to be ex parte was delivered to the state or is accessible by the state or is not locked down as it should be. Even if it is somebody's error, that's the way it should have gone. And I think that the judge should have somehow reprimanded the state for continuing to read something that is marked ex parte. They should know better.
And she may have in an email behind the scenes. Who knows?
Doubtful.
You'd think that she'd include that here. Like I have, it's
right.
not treating them
no
differently.
Way she did. She would 100% include that. And moreover, if you're McClellan and you read an ex parte communication between defense counsel and the judge or filing, and then double down and admit it in a pleading, which is what happened here. Like that's when I was like, what? All right. So this dude read an ex parte communication, then decides to admit it in a filed pleading. I don't know.
Yeah. And quoting that pleading, I think it's 3 or 4 pages in, so it's not like he's not quoting the introductory paragraph.
Right, exactly. So, like moving forward, accusations of violating rules on access to court records have been completely explained and dealt with, including by the Indiana Supreme Court in the first writ of mandamus filed by the defendant. So that one's that's a non-starter for me. I mean, she went and corrected all of her errors in terms of the record early on, I think, in terms of access. So I don't think we need to belabor that point. And it was one of the weaker points in terms of bias anyway. Counsel,
except let me say this about that.
I was going to say the same.
Let me say this about that, and that is, original actions are rare. They really are. And I don't know what other cases she's done this in. It clearly had to come from her that these things weren't getting put on the public docket. And yeah, she corrected it only as soon as she got caught.
Right. Well, I mean, that's $1 million question, though.
But that's the point. I did think it was relevant to include, even though it's now been rectified. It does go to part of the issues and possibly the bias as to what she was choosing to take off and what she was choosing to leave on. And for her to just be like, well, it's like basically her trying to say in this little, it's been completely explained and dealt with, including by the Indiana Supreme Court. But the fact that the Indiana Supreme Court had to deal with it, as Michael just stated, is a huge deal. She had to have her hand slapped by the Indiana Supreme Court before she did it. So,
like I was saying, the $1 million question is if this is par for the course for her, though, because we're talking about bias. Okay. So,
right, I see what you're saying.
Right. Well, you would have heard it, except you jumped in right before I was going to say it. So, but yeah, I mean, I obviously hear what both of you are saying. I think it could definitely play towards bias. My point is that there's much bigger issues that I think show bias than her shitty performance on the record in terms of her making a record. But I mean, I hear what you're both saying. But
well, it's one of the it's one of the things that, well, so there are 2 levels of things. There's a series of things that I've said all along she literally had no authority to do. And then there are the things she did that, yeah, she might have had the authority, but it was just plainly illegal.
Right. Yeah, I mean, she was off the rails with everything. I mean,
well, it started with the gag order. I mean, I've said it. I feel like I'm repeating myself. It started with the gag order when she gagged the families.
Right, exactly.
Right. You've got no jurisdiction over the families. What's happening? None.
And that seems to be a trend throughout the country with judges thinking they have some kind of jurisdiction over gagging family members, which is bizarre and incorrect.
Well, and then she was threatening you all. She was authorizing, McClelland and through McClelland law enforcement, threatening you all with contempt if you didn't turn over whatever pictures you had.
Right.
I mean, no.
Right. And we didn't specifically have it, but yeah, she was threatening other YouTubers and content creators.
Yeah.
Right.
Who have no special First Amendment privilege, who are not journalists and have no special privilege.
Right. She just determines who's a journalist and who's not a journalist.
Well, but leave that aside. There's a little thing called the First Amendment.
Right.
That's personal, regardless of whether you're a journalist.
Right. And it's like we always tell clients and family of clients, well, yeah, the cops are telling you not to talk to anyone about this, but they can't really make you not talk to anyone about this. It's just more like, really, it's a request, although they're making it seem like a demand no one has the ability to go against. And when a judge does it, obviously that literally is a demand that she had, like you said, no legal authority to make.
Well, and at least the reports of the Holman's interview with Fortson he was literally threatening him with jail, like, angry judge, and you're going to jail if you don't hand over the stuff.
Right. Yeah, I remember that being shocking. Like,
Yeah.
he called the judge during the conversation and, like, comes back and, like, the judge is pissed, "You better do this."
Well, I
And
mean,
she's like, "I've got no idea what's going on in the investigation."
But
well,
he doesn't do that without the email from Gull to McClellan.
100%. And you know, you have to consider what the end result for that poor gentleman was and how much impact that may have had. Like, because the only thing that I could think about with that was that Fortson's, like, the last thing that his wife said that he says, as long as they come clean, I'm going to be fine. You know, and then you have Holman coming in here threatening him at the alleged behest of the judge. It was like that whole situation was just.
Well, and I've been saying for a while, I thank God. I mean, speaking of things that, consequences from things she's done that she can't do, that whole contempt hearing in March. I mean, at least nobody we know about died in an automobile crash going or coming to, or was seriously injured going or coming from that absolutely useless, legally unauthorized hearing.
Yeah, I was real big in pointing out what a huge waste of time that was. Like, I thought that your motion handled that. Like, I think any reasonable judge would have done exactly what you said in that circumstance and required McClellan to respond in writing. And, I mean, you were right on the law based on the law that you cited. I still don't know to this day. And I sat through the entire thing.
How she got around it.
How she got around it. And
she got
right,
around
whether it was
it.
civil or criminal.
I don't know if I still don't know if it was civil or criminal.
Oh, no. She said they didn't prove beyond a reasonable doubt the contempt allegation.
So I guess that makes it criminal, I guess.
Yeah. But no, the way she did that and got around it was that by March 18th, a speedy trial date had been set, and so there was no time for an original action.
True.
All right, so let's keep plowing through. Counsel claims their motions are treated differently than those motions filed by the state. I mean, like, just from that paragraph or that sentence, I always feel like the state has a huge advantage with judges, but that's, I don't know if that's just me, but the court has set hearings on pending motions, which have now been continued due to the filing of this motion to disqualify.
But only after they requested a continuance.
Right. When defendant files pleadings, the state is entitled to file a response. The court follows Trial Rule 6 regarding time and gives the state 20 days to respond. Defendant is also given 20 days to reply to the state's responses. Once the issues are closed, if a hearing is required, one will be set.
So, Michael, does Trial Rule 6 apply to criminal cases?
Absolutely not, and that's hilarious. That's hilarious. And in the third motion to recuse, like, the trial rules apply when it's the state, but they don't apply when we want something, but they apply when the state wants something. Look, if somebody wants to look it up and say Trial Rule 6 does apply, have at it. I could be wrong, but I can't imagine. Trial rules do not apply to criminal cases.
All right. Defendant asserts that the court ignored his request to set aside 2 weeks for the defense case while refusing to set time limits on the prosecution. On March 6th of 2024, defendant filed a motion for a speedy trial. The court granted that motion on March 7th of 2024 and set the case for a speedy trial May 13th through the 31st, 2024. You want to say something?
Yeah. So Criminal Rule 1.1 says the Indiana Rules of Court, that's the trial rules, as well as all statutes governing procedure and practice in trial courts, apply to all criminal proceedings unless they conflict with these rules. So, you know, she may be wrong about the
Right, then 52 would apply.
yeah, she may be maybe I don't have to deal with the trial rules too often, so the criminal rules too often, so
I mean, that's what ours say as well, like that our civil rules apply to the criminal rules unless it says other, or unless there's a you know, a conflict. And I just pulled up the, you know, rule 6 didn't say anything one way or another, but I looked at the scope of the rules, which starts out that it applies to all civil, you know, civil cases. But
All right. Let's keep plowing through. The court granted that motion on March 7th, 2024, and set the case for speedy trial May 13th through the 31st of 2024. On April 30th of 2024, the defendant filed a motion for a pretrial hearing, which the court set for a hearing on May 7th of 2024. At no time prior to the May 7th, 2024 hearing, did the defendant advise the court that 3 weeks for a trial was inadequate. At no time prior to May 7th did the defendant indicate a belief that 3 additional weeks could be added to a trial without notice to the court, witnesses, and more importantly, without notice to the potential jurors. While the court agrees that a continuance of the trial is harmful to the defendant and the state, it could have been avoided had counsel communicated prior to May 7th, 2024. Counsel represent that they notified the court on or about October 4th of 2023 that they would need 2 weeks to present a defense. But the court has no record of that communication nor any recall of such communication. Counsel's assertion that, quote, between all defense counsel with a combined 70 years of experience, not one time have they been told that a trial would absolutely end on a certain day and not go any longer, end quote, is irrational and unreasonable. The court is aware its colleagues across the state routinely give trial dates that begin on a set date and end on a set date. What say
not
you?
a firm set date. I mean, yes, they ask, you know, like I've never had it. Well, you did the longest trial that we've ever done. So was it in the Anthony Garcia in Omaha? Was it a firm stop date?
No.
Right. So usually what they do is they obviously want to try to tell the jurors how long they're going to be here. So, okay, this is going to be a week trial. But I personally have never had it where it was like, we are not going another day. So you must finish, you know, this day. In a hearing all the time. You know, like sometimes a judge is going to like cut you off and tell you whatever you get through now you're getting through, which is, you know, whatever.
I think the answer is to go look at the transcript of the May whatever hearing.
Teresa from Criminality is telling us the answer that Rosie actually tells her in June of 2023.
She's gotten all the transcripts.
Yeah, she's gotten the transcripts. Well, she got the safe hearing transcript from back in June last year. She's got the more recent one too.
Yeah, but when they asked for the continuance at that May hearing, that transcript, it would be interesting to see what she said about. My recollection is she basically said it's ending on May 31st.
That's what I'm saying. I think Teresa got that one too. Correct me if I'm wrong, Teresa, but I think she got that one.
Oh no, she absolutely got it. And I'm saying to answer this question, I mean, you know, whether Gull is accurately reciting something here or whether it's
to be able to
record
to impeach her right here would be nice. Yeah, I agree.
I think that's what Teresa just did. That Rossi told her in June that he was going to need, what was it?
2 weeks.
2 weeks.
Right. But I've never.
There's
Go
a
ahead,
second
Michael.
part of it. There's a second part of it, and the second part is that she never told them there was an absolute end date, and I think that's mistaken. I think that's contradicted. Again, I could be wrong, but I think that's contradicted by the transcript of the May hearing.
Well, it's contradicted by the email where she clearly says that this isn't a give or take or more or
Yeah.
less conversation. This is
Yeah.
a stone cold date, and it's
Yeah.
ending. Like, I mean, she unequivocally says that in an email. I don't know if it's on the record, but it was certainly in an email. And moreover, what's the most problematic to me is that I've never had a judge, and I'm sure Allie will confirm, wherein they have not inquired as to counsel prior to trial coming. Once we've gone through everything, like, who cares what you're guesstimating a year out from trial? You get these attorneys in front of you as trial is looming, and you say, okay, now you're going to have a pretty good idea. How long is it going to take you, in your best estimation, to present your case? She never did that with either of them. Like a normal judge, like that's my, like, I always look through the lens of what a normal judge would do. And we've had plenty of judges that aren't fond of Allison and I and our, the way that we present cases, and that we're pretty aggressive. And, we've had, judges that aren't fans of ours. Notwithstanding that fact, they still act in a judicial manner. And if we have a trial pending, they come and invite us in, and we have a conversation with the state, and we all try to come to a reasonable conclusion as to how long that we believe that this trial can last, for the benefit of the court and its docket, and moreover for the benefit of the jury, the potential jurors who will have to sit in a jury box. I mean, I've just never. It's a shitty way to run a case. And
Look, I mean, what in a reasonable world, what would have happened was Brad and Andy filed a motion for a speedy trial, and the next day she's on a Zoom meeting with them, Ann McClellan, saying, "Okay, how many days do you all need?" And Mr. McClellan, how many days do you need? Mr. Rosie and Mr. Baldwin, how many days do you need? And then you look at the calendar and see where you can stick in that many days.
Exactly. And whenever I'm asked, I always say, well, you might, err on the side of longer on the state's estimate because, sometimes my cross examinations go long. Like I tend to be, I tend to go towards the long side. So I like to even warn them.
no,
Yeah,
wait, you
stop.
tend to, you only
But
tend
I
to.
warn them that when they're trying to decide how much time to set aside.
All right, let's keep going. Trial court. Wait, is that the one I just read? We just read the trial court is not guaranteed to equal time for both the defendant and state, or is that? Oh no, we got to read
No,
that.
we didn't get to that one yet.
Okay, the court is not required to guarantee equal time for both the defendant and the state. The court is required to guarantee sufficient time on the calendar and sufficient notice to jurors and the parties to present their case, however long it takes. Had counsel notified the court within days of receiving the March 7th, 2024 court order setting the case for a speedy trial, May 13th through the 31st, 2024, that the time allotted on the calendar was insufficient, the court would have immediately rectified the situation and extended the trial to May 13th through June 14th of 2024. Trial is now set for October 14th, November 15th, 2024, as requested by the defendant. Same argument. You have counsel come in and you figure it out together. She's full of shit.
I just think,
That's my legal opinion.
As Ali said, I think that, or maybe you said it, contradicts the email, and I think it contradicts what was said in that hearing.
I do too. And it contradicts common sense and the proper way to run a case.
It's the correct statement of the law. She doesn't have to give each side equal time, but she needs to determine how much each side needs, and then,
right.
No.
And that's the part that matters. The part is that is relevant to me is the part wherein she doesn't bring them in to try to figure out before she sets this date just to be shitty. Like because she did that, and now she's putting, we have no way of knowing if what she's saying is true. That had they said something that she immediately would have rectified it. Well, it's easy to say that after the fact. We don't know that that's true. I've seen nothing in the history of this case and the way that she's handled it that would lead me to, like, for 1 second to believe that that's what she would have done. As a matter of fact,
No,
I think that the opposite.
No, the email I mean, I think the email is essentially saying she wouldn't have done that. And again, I think we need to, look at the transcript of the May hearing, just when the continuance was finally asked for, to see what that exchange was, because I just don't remember.
I don't know.
And what she's doing here, I mean, it'd have to be fly spec'd, but what she's doing in this order, by coming up with these really questionable factual assertions, I won't call them findings, you know, on one view, it's making stuff up. And, she's, DQ3 coming.
Yeah.
Right.
Yeah. All right. So counsel accused the court of engaging in extrajudicial activity. Counsel is correct that on July 9th of 2023, the court commented on a Facebook post about a softball tournament her granddaughter participated in Delphi. The court did not attend the tournament, but did say congratulations to her former daughter-in-law's post about their team winning the tournament.
Now
If
let's take
counsel,
this in two parts.
okay,
I'd like to hear Michael's thoughts on that, because I thought that's a viable issue. Is her explanation here make it any less troublesome that she commented?
I when I saw that, I don't know what the law is. When I saw that, I thought it was total make weight. I mean, I just don't see it as a problem.
I agreed with Michael.
I
also
read some
thought it was
case
more
law,
of
and I
a,
thought it had some kind of legs. I forget the case law now, but it I don't think it was like necessarily like a huge thing, but it definitely seemed like it was in the realm of possibilities of things that the courts have considered. Maybe it was from the law that they cited in the motion itself. And now when we talk about this second part that Bob's about to read, I don't know that it's a that it's an anticipatory ruling, because I think that she does have to rule because the motion's been filed. It was just whether or not this judge was going to remain on. And if she did remain on, then she will have to rule. But go ahead and read the second half of this.
all right. If counsel's allegations in this part of their motion are well founded regarding a potential witness alleged social media activities and are presented to the court for ruling, the court will rule accordingly. Concerns about anticipatory rulings are not reasonable.
So what do you take from that, Michael?
I don't.
So they're talking about the nurse. So the nurse who took, right? No, not the nurse. Was it the psychologist or the?
Yeah, they're going to have to get that. I mean, if they're talking about the psychologist,
they're talking about whatever her name is.
Walla.
Who was in
And there's
all
already a motion pending to exclude or suppress that the statements made to her. So when she says these are concerns about an anticipatory ruling, or that she's not going to make an anticipatory ruling, that's not what they were arguing. They were arguing that if you see no issue with you postings on, social media that refers to this case, then, how does that look when you are, or does that create a conflict as you are now, unless you're removing yourself, which you are not. So you will have to rule on whether, the nurse or psychologist's, posts were an issue.
Yeah. And
Yeah,
she doesn't have any evidence of what the psychologist did in front of her. I mean, I kind of take her point here.
Yeah,
All
and
right.
that's I mean, they've got to have, and they've either deposed her, or they're going to be deposing her, and I'm talking about the defense. So, I mean, if there's anything there, I'm sure they'll bring it up.
So
I think at this point, and Teresa did confirm it was her. I always knew it was her. Like, if she joined our group the day of the safekeeping hearing back last June. Like, that's when I didn't know who she was, obviously, but when she became a public name, I then, like, somebody tweeted it that she had joined our group on the day of that hearing. So, I mean, it was clearly her. Whether or not that leads to an issue in terms of her ethics and her duties, I don't know. I mean, we'll have to find out more. Defendant asserts that the court has denied reasonable requests for funding. This is incorrect. Counsel is well aware of the amount of funds the court has authorized for the defendant. The court has requested the defendant to submit proper invoices and bills for Carroll County taxpayer funding. Invoices which have been submitted without appropriate documentation have been returned. The bill counsel refers to for $26,000 for investigative services from June 4th of 2023 through October 16th of 2023 was in fact returned to counsel, as no documentation was provided for services. No documentation was submitted until quite recently. With that proper support and documentation, the court authorized that invoice for payment on May 17th, 2024.
that's the same day that this motion was filed. The motion
Right.
to disqualify. That was the file stamp here is 3:04 p.m. So
Yeah. I know Brad didn't get paid forever. I don't know what her excuse on that was. That a improper invoice for that too? Guy wasn't paid for months.
I'm not going to comment on this stuff.
Yeah.
okay.
Defendant complains that public confidence in this case is eroded. This counsel should know criminal cases are tried in a court of law, not in the court of public opinion. An independent.
The letters were, you should just skip. Are we in the section about the letters?
Yes.
No, are we?
Just skip it. I mean,
Good.
that should never have been in there. I mean, I don't know what they were thinking.
I think they were trying to say, hey, the appearance of impropriety and the optics of it, as you got that comment there, are having an effect, because look at all these people writing letters. But I mean, I see your point, Michael, that those letters really,
I don't know why
Bob
she
and I,
keeps putting them on the docket.
If a judge can be run out of town by a letter writing campaign, then you just got the letter writing campaign going, and the state courts aren't going to, Indiana state courts, I don't think any state courts are going to really stand for that. There's so much other stuff that should have been there, and this should not have been, in my opinion.
I agree. Like, I don't give any credence to the letter writing campaign. I've never read one of them on any live, because I think it's absurd that she puts them on the docket when you've got unhinged people from Norway or the Netherlands, right? And she's putting them on the docket. It's just bizarre to me. All right. So defense counsel alleged bias by the court, only allowing cameras in the courtroom on one occasion. The court has not allowed cameras in the Carroll County Circuit Court due to its limited size and layout. The court did allow cameras in the Allen Superior Court at the hearing conducted on October 19th, 2023. The hearing was not conducted, and the media outlet providing pool coverage did not comply with the court's directives regarding coverage and broadcasting of the proceedings. The court lost confidence in the ability of the media to cover hearings appropriately. Bullshit. What bullshit. What a crock of shit. That's my legal. I don't even want to talk about it. So I'm not going to let you guys talk about it. The court has issued adverse rulings against the defendant as well as the state of Indiana. Adverse rulings do not support a reasonable basis for questioning the court's impartiality, nor are they grounds for disqualification. They are just adverse rulings. So accordingly, defendant's second verified motion to DQ judge and request for findings of fact and conclusions of law upon denial of this request, if this court denies this request, is denied. All right. So there's that. Not surprising, obviously. So
She doesn't
Michael,
address the appearance of impropriety at all, though. I mean,
she doesn't care. She just went through that laundry list of excuses as to why everything's fine and dandy. So Michael, I know you've got other things to do. I don't want to keep you much longer, but I want to talk about the effect of this. I want to hear predictions from both of you, what you think, if anything, will occur from the defense side of this in response to this particular order.
Well, I it's kind of going to be up to Brad and Andy and the people who work on such things, whether there's going to be an original action or whether there's going to be a motion for interlocutory appeal, or whether there's going to be a DQ3 motion. I don't know. I mean, I would want to fly spec the factual findings into the assertions. I would want to fly spec her factual assertions into to the extent they can be completely contradicted. I might want to do an original action.
so you think this could fall under an original action and not have to go to an interlocutory appeal?
Well, Judge Gull holds the keys to an interlocutory appeal. And if
if there's a chance for her denying it, then I think that makes a clear path to another OA. Whereas I worry, in light of them talking about what an extraordinary circumstance it was for them to hear it, as you've said, they're very rare. I just think taking the path that you're supposed to take and rolling the dice, and Judge Gull makes it very easy for them to go the OA route if they make the motion for the interlocutory appeal and she denies it. Well, they say, okay, well, we tried the normal route, the required route, and she didn't allow for it, so now we're going over her head again. Sorry.
Absolutely. But so here's the deal with that. And maybe it is the better way to go. You file to certify the question. That's easy to do. She's got 30 days to rule on that. If she doesn't rule, it's deemed denied. But the interlocutory appeal goes to the Indiana Court of Appeals.
Right.
Every trial judge's best friend. And then you're into a petition to transfer if you lose in the Court of Appeals, even with expedited briefing. Then
I mean, to me, like, Allie and I had a pretty heated debate over the weekend at CrimeCon about this particular issue, and Allie was of the mindset that they could push it, because like my concept was, look, the issue for Richard Allen and his attorneys is, to me, it's inevitably, if they take the route of an interlocutory appeal, it's inevitably going to end up in this October date being kicked, because everything will be stayed. Nothing will be litigated while that's pending. And, Allie's like, well, maybe they can, speed it through the system. And like, I wanted to ask you, Michael, in your experience, I mean, is that something that happens?
Well, you can ask the Court of Appeals. I mean, if Judge Gull certifies the question about whether she should be recused. And by the way, I mean, I really think that a judge failing to recuse him or herself really is more properly the subject of an original action. But doesn't mean you can't do an interlocutory appeal. And yeah, you can ask the Court of Appeals for expedited briefing and 15 days and 15 days, but you can't order the Court of Appeals to decide in a huge hurry. Maybe they will, maybe they won't. And if you get kicked on the original action, then you go get kicked on the original action, you go back. Well, maybe you'd have to get the original action in pretty quickly to beat the 30-day clock on the motion to certify the question for interlocutory appeal, because you'd want to file that if you got kicked on the original action, and then if you didn't get this question certified, you want to refile the original action. I don't know what you do.
Yeah, it's I just fear that if they go the OA route, that they're giving the court, who's already ruled in terms of her removal. Granted, they argued not one iota of it in front of the Supreme Court. I mean, I sat in there. Her name wasn't even mentioned. So, my prediction wasn't in terms of what was going to happen was pretty easy, in the sense that clearly they weren't going to remove her because it wasn't argued at all. And, to your point, Michael, I know you and I have talked, and you and Allie, we've talked off air, and, you think that there were many things that should have been brought up that weren't, and that fact still remains. But at the end of the day, I think the real evaluation in this thing is, I still don't know if the most recent stories that have made their way out to the public about Richard Allen attempting to take his own life in there are true or not. But you have to be concerned about your client's safety and, his ability to make it to trial alive. The defense has said that on more than one occasion, that was the reason for them pushing the speedy. That's why they filed the 70-day. They were genuinely concerned about their client's ability to make it to this trial breathing. So, and that, I don't know that that's changed. And if there's any truth to the most recent rumor, then I think that makes it even more problematic and really kind of ties the defense's hands in terms of, but they had to know. I mean, we all knew. I thought there was 0% chance that she was going to recuse herself. So it's like, do you file these? What is the purpose of filing them if you know that what the initial result from Gull is going to be, which is going to be, it's going to be denied if you don't have intentions on moving it up the chain. You know what I'm saying? So it's like, it's a difficult thing to kind of wrap your mind around from the attorney's perspective, for Andy and Brad on how to proceed with it. It's not a clear-cut answer. It's easy for us out here in the world to say, oh yeah, file the OA, do this, do that, but we don't necessarily have access to Rick Allen to know where he's at mentally.
Well, the OA would be, I don't think the OA would necessarily delay the trial. It might, but
yeah, I mean, they got to it pretty quickly, but
there's also the chance that further investigation is going to bust this case open.
Yeah, it's true. It's true. All right. Well, there you go, folks. That is the most recent update on the case that never sleeps, which has actually been taking a nap recently. So it woke up here a little bit, and I anticipate there's going to be some more stuff coming down the pike, and we will see.
Safekeeping hearing should be happening.
Should be. Well, I mean, now she's free to do whatever the hell she wants, depending on what the defense decides to do. If they choose to stand pat, then store's open for business, and we're back to hearing things, and she can reset hearings and hear them. So yeah, that we theoretically could be getting into a lot of stuff, and there's still much to be heard in this case.
Well, and one thing they could certainly do is try and get an early hearing on the third party defense stuff, and get a ruling on that, and maybe certify both questions for interlocutory appeal.
Right.
True story. True story. All right, so we will wait and see what the next play is here. We will. I wouldn't be surprised to see if I'm Gull. I'm firing out an order tomorrow, resetting a bunch of hearing dates, so that when they file whatever they're going to file, if they do, she can then turn around and blame them again for all these things being continued. Well, I scheduled them again, and now the defense has filed this, so we can blame them for all the delays in these hearings being heard. I mean, that's standard practice in this case for Judge Gull. So I wouldn't be surprised to see some hearing dates come down in the next couple days.
Yeah, the contempt information didn't cause any delay, of course.
Right.
Yeah. No, it's all right. Well, Michael, take care of yourself, and we really appreciate you coming on concerning, to go through this in consideration of everything that's going on with you and your kitty. And again, sorry for your loss there. Family pets are brutal to lose. So,
Yes.
And I'm sure every pet owner and lover in here will concur with that sentiment. It's losing a family member. So I'm sorry to hear that.
And then our child moves tomorrow. So,
oh man, that's brutal. You're gonna have a real empty nest, man. So, well, take care of yourself, and we appreciate you always coming on.
Thanks, it's been fun,
and we always appreciate your
Michael.
thoughts. All right, thanks. All right, babe. Good job.
Did you thank everybody over here that gifted stuff? And
I did. We had Kasha, one of our wonderful, amazing mods, gifted 5 DD memberships. We thank you so much for that support. Lady Die 2 came in hot with gifting 5 DD podcast memberships, so 10 total. It's beautiful. We got 10 new members because of those 2 generous ladies. And Stacy B, member 4 months, thanking us for breaking down the Delphi dumpster fire. Always. That's what we do. It's what we love to do. It's what we love to do.
I hope City Kitty's cat's feeling better. Wow, she had to leave CrimeCon early because of a sick kitty.
We almost had to leave early for a sick kitty.
Child.
Kiddy. Allie got a call on Sunday that our little one was not feeling well at all. But we actually couldn't get an earlier flight even if we wanted to. So we got a late love from Michelle. $10 holla. Appreciate you so much. We appreciate that support. We truly, truly do. It is what keeps us operating, keeps the lights on, so to speak. So, all right, you guys, we adore you. Thank you so much for hanging. We had a nice crowd tonight with no notice, per usual. I didn't realize an order had come down because I was deep into Reed all day with Jay. And just a little reminder for those of you that are not following Karen Reed, or for those of you that are, court is dark tomorrow. No trial, but Jay and I are having Jack of Never a Truer Word, who breaks down every single thing that comes out of people's mouths to try to determine whether or not they're full of shit. So, and he is currently going to be doing part 2 of that regarding one Miss McCabe, Jen McCabe. He is breaking down her testimony, and we're getting to the good stuff tomorrow. We're getting down to the house long to die in the cold. Did she do it at 2:27 a.m. or didn't she? Jack's going to hopefully give us some insight into that tomorrow, and that's at 1 p.m. Eastern, 12 noon, high noon for all you Midwesterners. So we'd love to see you there. On the way out, if you'd be so kind as to give us a thumbs up, we'd really appreciate it. It helps get us out into the algorithm, whatever the hell that is. But we hear that it works, so we'd appreciate you guys if you give us a like, share, subscribe. And if you really like what you're hearing and seeing, maybe become a member. Because without you guys, I'd just be an old man
talking about a lot of cases. And then, babe, stay on after you play the outro because Michael wants to chat.
Okay. Love you guys.